and welcome to Obidati Family TV. The program now Hope Alive. Yes, hope day and now plenty hope day because we no go run away from Nigeria. Now for this place we dey and we must get our country back. Now the major thing wey dey very important. Today will be Sunday. I know say on the get plenty Sunday. Our people will be say dem dey everywhere around the world. I greet you on a good morning, afternoon, and evening, depending on your time zone where you watch us from. Today, we want to deal with something where they very, very important, exclusively P2B's appeal now with the day at the Supreme Court. Because many obedience and well-meaning Nigerians worldwide, they don't they ask us, say, wetin be the grounds where we say we carry the go for this court of appeal, for this Supreme Court. Sake of say we don't dwell well for waiting concern article and the certificate forgery too long. They come they ask waiting they happen for Supreme Court. We no get matter again there. Na article matter we get no. Article matter they important to all obedient and well-meaning Nigerians because that very one they very, very vital. But today, all the questions and these things we don't carry and come, we want deal with these 51 grounds where we say P2B carry go Supreme Court. And not be only me there for student today will be Sunday. And Princess leave as she finished from church. Now she come say make we deal with this particular issue where be the 51 grounds where we there for Supreme Court. As P2B don't already talk say now this very 51 grounds now be the major grounds where we say you go deal with our matter or you go finish with our matter for Supreme Court. So, Princess.
Good day, well-meaning Nigerians and my fellow obedient worldwide. Welcome again to Hope Alive. Nigerians are suffering or rather paying the price for the sins of INEC and the rogue judgments given by PEPC. You know, this is the consequences of handing over the affairs and well-being of over 200 million Nigerians into the hands of someone that doesn't know his onions well. Well, join us as we discuss today.
Yes, especially this has to deal with the 51 grounds. As we won't start, you talk say you go the fire so that I go they dissect them to our people, make we for summarize the things for them. Make we no carry too much talk as today and as summary now we did.
Yes.
So let's start with the grounds where we say this thing. But notwithstanding, while we are going through the grounds, we should note that the major issues that we had was that about 13 of our witnesses, that is the subpoenaed witnesses that we had in court were disqualified or struck out by the presidential election petitions court, that's PEPC. They struck out all of them, saying that they need to have included their statement on oath together with the petition, which we are now bringing before the Supreme Court. That why would you bring people who you don't even know if they are going to come to court? You're more like forcing them to come to court. And then you are saying while you are filing the petition, you wouldn't have even gotten to the point where you know who you need to subpoena. You understand?
Yes.
So why would they all come together? You get my point?
Yes, I do.
So anyway, but let's start from the grounds that
okay, so quickly, it would be nice if you just give us a summary of grounds 10, 12, 11, 12, and 14, you know, from 10 to 14.
Okay,
you know.
So we'll be looking at summary of grounds of appeal 10, 11,
12, 13, and 14. Yes,
on
yes.
The notice of appeal. Okay, let's take it. You know, although the appeal filed by our own P2B and the Labour Party to the Supreme Court against the judgment of the Presidential Election Petition Court is based on 51 grounds, as you know. The major complaint that we raised against the judgment are, let me put it as in 1, 2. I'll just try to summarize it.
Okay.
So, the Presidential Election Petition Court was wrong when he struck out the witness statement on oath of 10 of the 13 witnesses called by the petitioners, on the ground that the statements were filed after the expiration of the period of 21 days prescribed by the 1999 Constitution as amended, for them to file the statements. We complain that the decision of the Supreme Court and the Court of Appeal, which the Presidential Election Petition Court cited in support of that decision, do not apply to the facts of this our case. That the Court of Appeal, which is the PEPC, in coming to the above decision, refused to follow its previous decisions in many cases, which were cited and submitted to it, that a subpoenaed witness not need to file his statement alongside the petition, and any such statement filed after the time allowed for the filing the petition is competent and valid. If you look at it, if you go to these grounds on the original thing that we have filed before the Supreme Court, you will see it under grounds 10, ground 11, 12, 13, and 14 on the notice of appeal. That's summarizing it.
Yes.
Yeah,
okay.
exactly.
That is because this obviously means that these subpoenaed witnesses were not necessarily supposed to maybe come in, like it's not a must for them to be there before they submit what they submitted.
Their expectation by that their rope judgment is that they should have compiled the witness statement together with the petition when they were bringing it ab initio, meaning originally. Meanwhile, these are not expert. These are subpoenaed witnesses. Subpoenaed witnesses are the one you go to court and tell the court, please give me a document so that this person must be compelled to come to court. So now they are now striking about 13 of our witnesses. They struck about 10 of saying they should have come together with that. So we are appealing to the Supreme Court to say it ought not to be so.
Yes.
Because there is no way you are going to say they are going to come together when these are subpoenaed witnesses.
They weren't even willing at first. They were more like compelled to come in.
These are among the severals on the grounds that we have laid.
Let's proceed. Let's see the 15 of the notice of appeal. You can 15, yes.
On the grounds, on grounds 15 of the notice of appeal, the Presidential Election Petition Court was also wrong when it struck out the witness statement on oath of petitioner's witnesses. That is petitioner witness 4. And then we have petitioner witness 7 and petitioner witness 8. You understand me? That is PW7, PW as they used to call it, who were expert witnesses on the grounds that they were persons interested in the outcome of the petition. They failed to consider and appreciate the decision of the Supreme Court to the effect that a person interested means a person who has a pecuniary or other material interest in the result of the proceeding. A person whose interest is affected by the result of the proceeding and therefore would have a temptation to pervert the truth to serve his personal or private ends. You understand what I mean? So the Presidential Election Petition Court failed to take into account that in this case there is no evidence on record in the instant case that any of the petitioner's witnesses had any pecuniary or material interest in the result of the proceedings. You get my point? So it is also their complaint, that is our own complaint to the Supreme Court, that the decision of the Supreme Court, a person interested does not mean an interest in the sense of the intellectual observation or an interest purely to the same party. It means an interest in the legal sense which imports something to be gained or lost. That is, that the interest of PW4 and PW7 and PW8 in relation to the documentary evidence produced by them on subpoena was merely products of intellectual exercise. The Presidential Election Petition Court ought not to have struck out their evidence on this ground. That is in ground 15. You see what this means? You know, for example, the lady that came, that testified about the INEC portal, that says it was good, that nothing happened to INEC portal, you know, they struck her witness statement out and saying that she's a party member, she's somebody of interest, and all of that. So here we are trying to tell the Supreme Court, you don't need to kick her out, because the moment they kicked her out, it means that her testimony, her evidence, and all those things are going away with her. So we are taking that to Supreme Court, say they erred, they made an error. They shouldn't have talked her. She might be a person who is a party member, but is she interested on the presidency? You understand me? No.
Yes.
So those are the things that we cited in that very place.
Oh, okay. That is okay. We'd like to go over to maybe from 16 to like 32, just so it will be fast.
Okay.
Do you understand? So that because we have a whole lot of grounds to cover. So let's see 16 to 32. You can make a very quick summary of it.
Summary of
16, 17, 18. Yes.
To 32. Wow.
Yes, to 32. If it's possible to like.
Oh, yeah, of course. Let me take it this way.
All right.
The Presidential Election Petition Court was wrong when it decided that the electronic transmission of results with the bimodal voter accreditation system (BVAS) from the polling units to the IREV is not mandatory under the provisions of the Electoral Act. Okay. You know, that is what we have been discussing in the studio for a long time ago. You understand? Yes. But they just came and trashed all of that. Now, we know that, and that INEC has a discretion whether or not to use BVAS to upload and transmit the result. In coming to this conclusion, the Presidential Election Petition Court relied on the decision of the Federal High Court in suit number, I think, FHC Abuja CS 1454 2022, and they refused and ignored the recent decision of the Supreme Court in Oyetola versus INEC, that is 2023. I might give all the citations that are available, but for now, let's move it fast. And Supreme Court made it clear in Oyetola versus INEC that the use of BVAS to scan and transmit the result of the election from the polling unit to the IREV is part of the election process. Part of the process. Now, under the new legal regime governed by the Electoral Act 2022, the Presidential Election Petition Court also ignored the decision of the Supreme Court in Oyetola's case that the regulations provide for the BVAS to be used to scan the complete result in Form EC8A and transmit or upload the scanned copy of the polling unit result to the collation system and INEC result viewing portal, which is the IREV. You understand me?
Okay.
Now, you know, these things are what we have been discussing a long time ago about IREV, which for a long time we have not even brought. But that is part of what we are taking to the Supreme Court. Okay. We are telling them that this is what they erred. They should have looked at the fact that INEC has said they are going to transmit this thing in real time and all that. So those are the things we are packaging on this. But we can look at it more and more on that is to further it.
Okay.
You know? It's the complaint also is that contrary to the decisions of the Presidential Petition Court, the use of BVAS to transmit the election result to IREV under the present legal regime governed by the Electoral Act 2022 is mandatory. We contend here in coming to the above decision that the Presidential Election Petition Court overlooked the provisions of paragraph 2.90 on page 36 of the manual for collation, that is officials, wherein INEC stated that the mischief, the introduction of electronic transmission of result was meant to remedy under the new Electoral Act 2022, with under the subheading electronic transmission / upload of results, election result, and publishing to INEC result viewing portal IREV, wherein INEC explained different things. One of them is that I want to quote: one of the problems noticed in the electoral process is the irregularities that take place between the polling units after the announcement of result and the point of result collation. Sometimes results are hijacked, exchanged, or even destroyed at the polling unit or on the way to the collation center. End of my own quote. So these very things are what were actually domiciled with the Supreme Court. It's simply reiterating the same thing we have been saying to the lower court, that is the Court of Appeals, which is the PEPC that we're talking about.
Yeah.
So these are what we are now back on at the Supreme Court saying, hey, we need you to take a look. These guys made a mistake. And these are the mistakes. You understand me?
Yeah.
For example, it was very clear INEC has discretion on what point to use, but they have told us where they are headed. And where they are headed is that they are going to do electronic transmission. And that electronic transmission that they said, they gave us a official guide manual, that 2.90, you understand? Where they made it very clear that, hey, the reason why we are going to transmit directly is that things might go wrong. So, so it's more like that process that P2B said he is looking at, that the process was flawed. That is what we're looking at. But let's continue, because this is a very long thing. So, the Presidential Election Petition Court also failed to consider that in the same manual and guidelines, INEC stated that it became necessary to apply technology to transmit the data from the polling units such that the results are collated up to the point of result declaration. The real-time publishing of polling unit level results on the IREP portal and transmission of the same results using the beavers demonstrate INEC's commitment to transparency in result management. That is still what INEC said. They said this thing will make it very transparent that they are doing the right thing. You understand? Which they never did. So all these complaints are what we are bringing before the court. It is now up to the court to look at it to see whether the court, this rogue judgment, or what we call the rogue judgment, whether they actually erred. Because Supreme Court is actually a court of a court that they are not the same thing with the Court of Appeals. No, you understand me? So they are much more matured, and their own is to interpret the Constitution and electoral. Anyway, we'll get to that very point. We further argued in the complaint that since INEC itself had stated in the same paragraph 2.0 of the manual for election officials in that commitment, and that commitment is backed by section 47.2, 60.1.2 and 5, 64.4 A and B. All of these sections of the Electoral Act, we had virtually exhausted them in the studio here. You understand me? Saying where and where they were wrong, you know? Now, the Presidential Election Petition Court was wrong when it held that the provisions of the manual on electronic transmission of results conflict with the Electoral Act. They made the case that since the provisions of the manual complement the provisions of the Electoral Act 2022, in this respect, there is no conflict between the provisions of the Electoral Act and the guidelines and regulations. The issue of Electoral Act superseding or prevailing over the guideline does not arise in these circumstances. This is what you see from this very ground 16 up to grounds 32. You get my point? Ground 16 up to grounds 24. So the argument basically is about the rules according to INEC guidelines, the Electoral Act, you understand me? All those things that we keep talking about. The beavers. The beavers use, upload, direct to the this thing. So all of these are what has been packaged to the Supreme Court. So the arguments are before them. The evidence must not be with them. They are to look at what we have argued and what these people gave as their own judgment to decide, hey, but they must talk on each of these grounds that we have raised against the judgment that is before the court.
That is another way of making it as explicit as it can be. That's nice.
Yes, I'm just trying to, you know, narrow them down because of time. Because summary means we need to summarize it to our viewers to understand. That's actually.
We can go over to like 33, 34, and 35. Just these three. Let's see.
Okay.
33, 34, and 35.
Okay.
Yes.
Okay. Well, looking at this thing, I think in 33 to 34, the Presidential Election Petition Council was wrong when it refused to hold that, since INEC had represented and assured the whole world in the exhibits and videos recordings tendered by the petitioners in court that INEC, was going to use beavers to transmit the result of the election from the polling units to the IREV electronically as mandated by the Electoral Act 2022. INEC could not turn around in this case to now argue that it had discretion on whether to use the beavers or not. You understand my point?
Yeah.
So the point is, you have already told us the way you are headed. We have already set the goalposts. We have already set the goalposts. Are you getting my point?
Yeah.
So when you have set the goalposts to say, this is how it is going to be, this is how we are going to play the match,
Yeah.
you don't now come back and say you have discretion to move the goalpost to another post.
Yeah.
You get my point?
Yes.
So that is the argument we are bringing before the Supreme Court. They have said they are going to use beavers to do accreditation. They are going to use the same beaver to snap and send to the IRF.
Yeah.
They are going to use the same thing to send electronically, you understand?
Yeah.
So you can now come back and tell us that you have discretion to do any way you want to do, just like the lower courts are saying.
Yeah. They didn't even do it in the middle. They did it after the whole process has been concluded.
Exactly. So getting back to the this thing explanation, you know, so the decision of the Presidential Election Court makes a complete nonsense of the chief objective of the provisions of the Electoral Act of 2022. Contrary to the decision of the Presidential Election Petition Court, it is clear from the pleadings and evidence adduced that the failure of the first respondent, which is INEC, to upload and transmit the results of the election from the polling unit to IREV as mandated by law substantially affected the outcome of the election, in that the credibility, integrity, and transparency of the entire election process were compromised, could not be guaranteed. Those are from, look at ground 25, 28. You understand me?
Okay.
Yeah, ground 25, 28. Those are basically where these things are tethered in. So we are narrowing them down in all of these things.
Oh, okay.
So let's, as we go in, we know in different grounds, it's 51 grounds.
Yes.
But what I'm trying to do is munch some of the grounds that talk the same thing together. You understand me? So that we could be able to
faster.
Yes, so that we could be able to proceed.
Okay, that means we can move forward to 36, 37, and so on. Like from there, we can stop around 44.
Well, let's see what the grounds are. I'll just look at briefly what the grounds that we have. But let me take it this way. The Presidential Election Petition Court was wrong when it declined jurisdiction to entertain the issue of disqualification of the second respondent. Okay. You understand me?
Yes.
Which is Tinubu, based on the alleged double nomination of his vice president. The Presidential Election Petition Court ignored and refused to follow its previous decisions, wherein it had relied on the extant decisions of the Supreme Court, and emphatically held that the issue of double nomination, as raised by the appellant's hearing, is an issue of qualification that can comfortably be brought and ventilated under Section 1381A of the Electoral Act 2010 as amended, and now Section 1341A of the Electoral Act 2022. The Presidential Election Petition Court was wrong when it concluded that the petitioners did not prove their case of double nomination of the vice president, Kashin Shettima, because the law and the evidence tendered in the court did not support that conclusion. You can look at it, you can see that in, I'm talking about in grounds 33, 34, and 35 of notice of appeal. Okay. You understand me? Okay. You can, it's clearly in those places, but I'm just trying to munch them up.
Okay.
So those are, this very one talked about Shetima, you understand me?
Yes.
They should have disqualified him based on Shetima, but we are bringing that very particular issue again in the purview of the Supreme Court,
okay.
so that Supreme Court could look at it, you know, and deal with it as it deems, as the law provides, really, because it's all about what the Constitution says and how it is treated.
Okay.
And again, we know that the Presidential Election Petition Court misapplied the provisions of Section 137(1)(d) of the 1999 Constitution as amended, when it reasoned and concluded that the second respondent, which is the Tinubu, was not disqualified from contesting the presidential election based on the forfeiture orders made against him by the United States District Court. The Presidential Election Petition Court wrongly read the provisions of Section 137(1)(e) of the Constitution, which is a different independent provision, together with Section 137(1)(d) of the Constitution, and concluded that there is no evidence that the second respondent had been arrested, charged, and convicted by a court of law to warrant his disqualification from contesting the election. So this one actually is going back to the forfeiture issue, you understand? So all those things that were already before them, you know, we have to recouch them, you know, the lawyers have to put them in order again to represent them that this is, they made an error when they did this. Then they went and used one section of the Constitution, you understand me?
To interpret.
Yes, to now, that's what they did. So that is what actually happened this thing. Now, what we took to the Supreme Court is we complained that the interpretation given by the Presidential Election Petition Court is contrary to the settled principles of interpretation and the abundant binding case laws cited and commended to it on the meaning of fine and forfeiture. The court below failed to give a broad, liberal, and purposive interpretation to Section 137(1)(d) of the 1999 Constitution as amended, as laid down and enjoined by the Supreme Court in cases too numerous to mention. You can see our grounds on grounds 36, ground 37, 38, and up till ground 44.
Yes,
of the notice
that
of
was
appeal,
what.
you
Yes,
understand?
yes.
So that is what you will find there. It's basically dealing with the issues that concern Shetima, then Tinubu's forfeiture in the US, the non-commission, and the way they interpreted that section, you understand me?
Yes.
Just trying to make a nonsense of the whole thing. So for now, I think I've dealt up to the
44,
level of,
yes. So we can now move to that, to 45, 46, up to 47. That should, yes.
Okay, I will tell you categorically that the Presidential Election Petition Court was actually wrong when they decided that a winner of the presidential election does not need to score at least 25% of the votes cast in the FCT. You can see now that one of FCT, you know, many people think that all those things have been passed, that it has been left unsaid or something like that. Nobody's talking about 25% of FCT, but they are all there. You understand me? They are all there, well packaged. So, you know, they are both at 25% under Section 1342B of the 1999 Constitution as amended. It is, we complain to them that the Presidential Election Petition Court ought not to have relied on the preamble to the Constitution to interpret the provisions, because the provision is clear and unambiguous. You know what they did is that they went to the preamble. That is, you know, the Constitution has a preamble where you understand. So they went to the preamble to interpret that very section. That's how they get to their 37 states. You understand? So, and it is said that once a statute or a constitution is unambiguous, you should just hold it as it is. You understand? It's the same thing we are presenting to Supreme Court to say, this 25% of FCT is unambiguous, it's straightforward. They don't need to go to preamble to find a way to, you know, to interpret and rule it out. You know? So those are the part of the things that this is clear and unambiguous. The law is that the preamble is an enactment, including the Constitution. It can only be resorted to in order to clarify any ambiguity in the words used in the enacting part, it cannot be used to give a different meaning to the clear wording of a provision. We also contended that the Presidential Election Petition Court introduced and relied on extraneous matters consideration in its interpretations of Section 1342 of the 1999 Constitution as amended, because the issue before the court was not whether or not FCT has a final status, like a special status over the other states. You get my point? Okay. What we took to them is not whether FCT, the question we sent to the Presidential Election Petition Court was not whether FCT has a special status. Yeah. Whether it is not, that is not what we sent to them, you understand me? Yeah. But they just went straight to dealing with those things like that. So, but the point is whether or not every citizen of Nigeria has the equality of vote, or whether or not the right of every such citizen to elect their president whose policies are supposed to and will affect all of them equally, regardless of which part of the country they reside or live, as erroneously invented by the court. You understand me? Yes. So we are presenting this just to tell them that what the court did, they erred. They erroneously presented that very something to dispel all of this. So I think that deals with the 45, 46, 47, 48, and 49. You understand me? Yeah. So it's more or less having dealt with everything. This. So you can see with all of this, first, we deal with the witnesses. Yes. We had about 13 witnesses.
And they ruled out 10.
And out of these 13 witnesses, it was just about 3 of them that we can say categorically that were taken, even if what they were dispersed of. You understand me? Yes. So we're looking at the 10 we lost over there, and we're saying they shouldn't have been taken off. Yeah. Then we looked at the other issues about Shetima, the double nomination issue. Then we look at the 460K for future. They are all there. Then we look at the 25% of our budget issue that were all dealt with. Yes. You understand me? So all of these things are before the Supreme Court. The Supreme Court for now has not even set up the panel that are going to adjudicate the matter.
But we got to find out that there's a head already. They have a head of the people that will be handling the court panel for this case.
I think those things are, should I say, permutations or suggestions. I think something that says about Okoro.
Yes, Justice Yang Okoro. Yes.
I think that is from a tweet.
Yes, it's a tweet. Yes.
Okay, if we have that tweet, maybe we could actually take up the tweet. Because they are saying that Okoro is going to lead, and this week that we're entering is the week they are going to unveil the 7-man justice panel. Yes. And that a lot of things have been going on because some of the justices of Supreme Court are rejecting the offer. We also heard that Ariwara has recused himself. Yes. Okay, I think that is the tweet. Let's look at it. Okay. You can bring it up, so let's have people look at it.
Okay, Justice Yang Okoro to head Supreme Court panel on presidential election petition. Justice John Yang Okoro has been nominated to coordinate the Supreme Court panel that will oversee the presidential election petition filed by the candidates of Labour Party, Mr. Peter Obi Gregory Obi, and the People Democratic Party, Alhaji Atiku Abubakar, respectively. News band gathered that Justice Okoro is currently, it says that Justice Okoro is currently coordinating other justices of the Supreme Court out of the total of 11 justices currently serving in the Apex Court. An insider, however, revealed to this medium that there is heavy arm twisting among the justices, as the majority are insisting on following the Electoral Act and the federal constitution governing elections in the country, devoid of technicalities. In the meantime, it was learned that the Chief Judge of the Federation, Chief Justice Olukayode Ariwola, and Justice Kekera Ekun have both recused themselves to avoid conflict of interest. Justice Ariwola, this medium was informed, recused himself over his long-standing relationship with President Bola Ahmed Tinubu, who is one of the respondents in the petitions. On her part, Justice Kekere Ekun recused herself over her relationship with Alhaji Abubakar, through her husband, who is a serving board member of American University of Nigeria, Yola, owned by the PDP flag bearer. Justice Okoro, it was gathered, is faced with an uphill task of securing an unanimous judgment from the 7 justices required by law to be on the panel. Another source, who spoke on condition of animosity, meanwhile revealed that the arm twisting involves the Department of State Security, that's DSS, and the Attorney General of the Federation, AGF, Yusuf Fabemi. Fabemi, the source said, is the middleman between the camp of the presidency and the Supreme Court, led by Justice Iyan Okoro. It is left to be seen whether the justices of the Supreme Court will uphold the Electoral Act and the Constitution, or whether they will rely on technicalities like the Presidential Election Petition Court. According to information gleaned from the Apex Court website, currently there are 11 justices, with the recusal of both Chief Justice Ariwola and Kekere Ekun due to conflicts of interest. Only 9 remain, from which 7 will be selected. According to the source, the 3 justices are under heavy pressure to either unflinchingly adhere to the Constitution without compromise, which will be a blow to the camp of Tinubu, or play along as the judges of PEPC were accused of.
Yeah, this one, the one will be say come out from tweet.
Yes.
And person will be say tweet and which person must have name tweet the.
Is PO grassroots.
First lady.
Oh, okay.
Somebody tweeted this. So our people get plenty people will be saying that they tweet, and some of them they tweet then go send to us, say see what thing they happen. And when we see and we look at the ones who we say it be like say it look like truth, and it be like say it will be truth, or it be like say this thing. So we'll use that very one they go. And it get one obedient will be say he send us message, he talk say what in they talk. I want share and with my name na Dennis Atabong. In send this very something come in, and waiting in send make I just tell on now waiting in talk from Dennis Atabong. He said, in order that P2B and Atiku may properly defend this case, it is necessary for them to lay the groundwork before the Supreme Court by defining the philosophy which they think is supposed to guide judgments in electoral matters. The Supreme Court is a policy organ. It should not be bound by rules in the way lower courts are bound. He said, what I'm seeing now is that everyone is just speaking of rules without, in the least, asking themselves whether those rules will lead to the discovery of the whole truth or will prevent the truth from being discovered. We often forget why those rules were made in the first instance. Anyway, Dennis, let me, before I continue, I want to inform you that these courts are not really about truth. They are about facts and not about truth. You might have all the